Picture the steps of the Supreme Court as dawn breaks over Washington. A clerk carries a sealed envelope marked Trump versus Barbara. Inside lie papers asking whether a baby born in Dallas, crying, breathing, innocent, belongs to this nation at all. It is a simple fact with a hard question hiding beneath it. How can a country doubt the citizenship of one born beneath its flag? That question may seem strange to modern ears, yet it is no small quarrel. For if birthright may bend to politics, then the bond between law and life begins to fray. And when law frays, freedom does too. But what power and what promise brought the court to this doorstep? In this present term, the justices face a crowded stage of questions. A president's power to command or to remove, the meaning of equal protection for the young and for the different, the limits of guns, ballots, and tariffs. Each dispute speaks in its own tongue, but all whisper one word: authority. Who holds it and who guards it? Picture the justices taking their seats, the ceiling light like cold daylight upon them. The clerk's envelope rests on their table, heavier than its pages. The trial of principle begins. The case of Trump versus Barbara asks whether the Citizenship Clause of the 14th Amendment, all persons born or naturalized in the United States, still means what it says. Lower courts said yes. The order denying birth certificates was blocked. Now the Supreme Court decides whether a ruler's pen may narrow a promise written in blood long ago. But power never argues alone. It brings history as its witness. During Reconstruction, the nation knew what it meant to be divided by birth and color. The 14th Amendment was the cure, the nation's vow that law, not lineage, determined belonging. The court in Wong Kim Ark of 1898 confirmed that vow for a Chinese-American child born in San Francisco. Yet now that very question returns: what if a child's first breath on American soil were not enough? It would mean that citizenship depends not on the Constitution, but on the mood of those in command. And that is where danger hides. For an executive who can decide birthright may soon decide worth. This is the door to unchecked rule. A door every free people should keep locked. Even presidents must bow to text and oath. And yet the story does not end at the steps of the court. It stretches back to the design of power itself. Think of the Oval Office, its desk covered with files on tariffs, agencies, and orders. The same hand that signs one decree over commerce seeks another over citizenship. How far may a president go in the name of unity before he breaks it? The founders debated that very thing. They gave vigor to the executive but leashed it with law. The president shall take care that the laws be faithfully executed. Not altered, not invented, executed. Power tempted even George Washington, but he stepped aside rather than seize what was not his. Andrew Jackson tested it. Abraham Lincoln, yes, my namesake, faced its might in Civil War and learned that command without conscience is no victory at all. A president may lead an army or steer the economy, but he may not rewrite the core of citizenship. That belongs to the people as a whole and the law they ordain. Picture Congress assembled under the Capitol dome, sunlight cutting through its high windows. Each vote there represents the only safe path for national will. Yet authority never sleeps. When one man claims the whole, others cheer for his speed. They forget that deep law moves slow by design. The executive must act with courage, yes, but courage guided by boundary. He who breaks the fence for his cause leaves the field open for all causes. Did history not warn us of this very temptation? It did, in every government that prized efficiency over liberty. Monarchs once boasted they ruled by divine right. Dictators later claimed they ruled by necessity. Both ended in ruin. America chose a harder path: rule by consent. That choice demands patience and humility. The slow grind of law protects what the swift hand destroys. Picture the courtroom in Sailor Law versus CFPB, attorneys arguing whether one president may fire agency heads at will. The dispute may sound technical, but beneath it lies an old heartbeat. Must power answer to principle? And so the same term finds the court hearing voices from every corner of liberty. A transgender student in West Virginia asking equal protection on the playing field. A gun owner accused under Federal Code Porum 922G3 for possession while on controlled substances. State officials in Mississippi arguing where race may or may not guide a district line. Each question aches with its own history. None stand alone. The Constitution ties them in one thread, the dignity of law untouched by whims of might. Some wonder, why not let the times decide? Why cling to words written 2 centuries past? Because words are promises. Without them, power becomes opinion, and opinion soon becomes domination. Picture Independence Hall, empty benches, sunlight on the old wooden floor. Every crack in that wood held the breath of men who feared not war, but tyranny born of ease. They wrote limits to protect future generations from themselves. Their warning remains for every capital, every court, every citizen. Still, law without mercy is cold stone. The amendment that made every child born under our flag an American also bound us to compassion. Equal protection is not comfort, it is discipline. It tells the majority to see the minority not as exception, but as neighbor. It tells government to measure its strength not by control, but by restraint. Picture a classroom in Charleston where children trace the words, "We the people," upon a chalkboard, their voices half in question. Who are the people? Everyone, and the teacher smiles knowing that lesson will outlive her own voice. That is where the promise of law meets the beating heart of a people. For every clause, every amendment, lives only so long as it is remembered not just in courts, but in conscience. A nation may outbuild any empire in might, but if it forgets mercy, it loses meaning. The child in Dallas does not argue case law, she only reaches for belonging. The justices will read the 14th Amendment in their chambers, but millions will feel its weight inside their homes. Equal protection is not simply a rule of state, it is a mirror held to the face of mankind. Think again of those marble steps in Washington after the decision is read. The clerk's hand trembles as the opinion is announced. Lawyers glance toward the crowd outside, some relieved, some afraid. Cameras hum along First Street as parents lift their children above the railings to see. The argument that began in a sealed envelope now changes lives beyond counting. Yet even that moment is not the end. The next case will rise. The next dispute will test the frame. The Constitution endures only by being used rightly, not loudly. The founders understood that self-rule is not self-indulgence. It is work, quiet, constant work, done by citizens who guard law's boundary without hatred. Power will always ask for more. Liberty must always answer enough. The balance is never kept by accident. It is held by character. The court may decide births and borders, but it cannot decide what kind of people we choose to be. Picture the Mississippi map tables once more, lines redrawn, debated, delayed. Picture the old flag above Ellis Island, where names once changed but rights did not. Picture ports of Long Beach, where goods move freely because words written long ago still restrain greed. These are scenes of quiet order, born of faith in law's steady hand. The lesson is plain, though seldom easy. Freedom is preserved not by the shout of the strong, but by the restraint of the just. The question before the Republic is never only legal, it is moral. For when power, fear, or anger tempt you to look away, duty calls you back to principle. And in that answer lies our hope. The Republic can be saved. When the time comes to choose between power and principle, which will you call your own?